Rejecting fact for faith, the inexplicable and inexcusable silencing of the PGAL's child client. When a PGAL, which is private guardian ad litem, is appointed to represent children in a child custody dispute in a Utah divorce case, it would sure be good to know what the PGAL and the children actually said to each other about the substantive issues for which the PGAL was appointed, instead of merely believing and trusting any secondhand sources' claims as to what the children purportedly said, but actually to know what the children said. And we could do that by having an audio and/or sound and video recording of what the PGAL and the children actually said to each other. Now, I'm not talking about confidential communications, of course, but I'm not aware of any evidence that proves or so much as suggests that having such a record is, not maybe, but is, prejudicial or harmful to anyone. The reasons why should be obvious. I don't have to believe you if you tell me that your fingerprints are not on the murder weapon. In contrast, I cannot deny your fingerprints aren't on the murder weapon when you show me the murder weapon has none of your fingerprints on it. If you had an eyewitness who could provide you with an alibi, if you were a criminal defense client, you would need the witness himself to testify. You couldn't say to the judge or jury, well, you could try it, but it wouldn't work. Trust me, I have an eyewitness, and if he were here, he'd tell you that Mickey shot Jerry. I didn't shoot him. Well, the only way to know if such a witness really exists and is not just a convenient figment of your imagination is to hear from the witness himself. Obviously. Indeed, if you tried to speak for a phantom witness, that would be inadmissible hearsay and probably make you look desperate. Objective fact is self-evidently more probative than unverified stories and claims. This is why we don't rely on hearsay when we can hear firsthand from the witness. You wouldn't want people trying to put words in your mouth and misrepresenting what you do and do not say. It's why the rule against hearsay exists, and for good reason. It's why the public rose up and demanded body cams for police, because the police were caught lying so much and chronically violating innocent people's rights in the process. It's why we need verifiable proof that medicine actually works and that aircraft can safely take off, fly, and land before we use them. Yet PGALs in Utah all but universally refuse to interview children on the record, and they oppose children being questioned by anyone else on the record. Instead, PGALs expect that everyone believe, 1, what the PGAL claims to have asked the children in the PGAL's interviews with them, 2, what the PGAL claims the children said in response, and 3, to believe the PGAL without the children being subject to cross-examination. In other words, believe the PGAL. On what basis, you may ask? Merely being appointed as a PGAL. Well, that's like expecting one to believe a witness in court merely because the witness swore an oath to tell the truth, which would be as unreasonable as it is irresponsible. Being a PGAL doesn't render one incapable of lying or render one incapable of misperceiving or misremembering details or even misreporting them. Being a PGAL frees the PGAL from personal biases and prejudice that hamper impartiality and sound judgment? Of course not. Indeed, if we took every word of the PGAL as gospel, we wouldn't need a judge to do anything other than rubber stamp what the PGAL says. If the PGAL says the children claim Dad beat them, well then that's what the children said. After all, the PGAL says so. No need to inquire into whether the children were coached, coerced, brainwashed, or chose to lie, or whether the PGAL chose to lie or simply didn't report the facts correctly. And because the law in Utah is construed to mean that children so-called represented by PGALs are prohibited from speaking for themselves, that's really what it is, no inquiry with the children on the record will ever need to take place. Does that sound like fact-finding, like due process, like just and equitable process to you? Even if someone subjectively believed a PGAL were infallible and could never lie and never misperceive reality, subjective belief would not make it so. It could not make it so. Subjective belief is inherently not and inherently can never be superior to objectively verifiable fact. Yet the courts indulge, and knowingly indulge, in this kind of thing all the time. Trust us that the PGAL is telling the truth because he/she is a PGAL. Or, we don't need to hear from the children directly, the PGAL speaks for them. It would be one thing if a PGAL claimed to speak for a child client and the child client could at least go on the record to verify, yes, that what the PGAL just proffered is correct. But we don't even have that. Once a PGAL is appointed, the child is rarely, if ever, heard from himself or herself, even when the child is willing to testify. I'm not kidding. I'm not exaggerating. Sometimes we don't have objective proof. Sometimes all we have to go on is believing or not believing someone else's word. Sometimes it comes down to your word against mine. But belief is plainly not the highest standard of proof, thank goodness. When we can rely on fact over faith, we are morally, intellectually, and in a sense legally obligated to do so. When accuracy and truth matter, and when do they not, and if and when we can hear directly from a particular person, himself or herself, not secondhand, then no one should trust what anyone, not just you, anyone says someone else allegedly said. Any PGAL who would assert, I have or could have objective verification for my claims, but I refuse to provide such verification, take my word for it instead, is a PGAL that no one is obligated to believe. I ask sincerely, how can any PGAL or judge or commissioner who believes that the PGAL serves to silence a child's own voice be trusted?